Welcome to the Republican Professor Podcast. Welcome to another semester. It's fall of 2024. And I haven't been with you since May 31st's post honoring the late John W. Boswell, Master Sergeant, U.S. Army retired, PhD recipient. And I went through that court case where Kamala Harris was a defendant. We almost had gotten through the entire thing, and I promised we would. Here it is, the start of another semester, and it's the fall. And I've been doing on, at least on YouTube, I've been posting videos here and there that aren't what I would normally call episodes that are freshly produced, but they're old stuff from like 2021 and a couple of older stuff like that. But we do need to get into finishing the case where Kamala Harris was a defendant. Of course, since last time, some things have happened in American politics. Kamala Harris is now the Democrat DNC nominee for president. And they tried to kill the Republican nominee, which his name is Donald Trump. And so this case has taken on a fresh relevance. Like my mentor, Michael Ullman, used to say, American politics is the gift that keeps on giving, and the American presidency is the crown jewel in that. So I'm on page 28 of 38 of Silvester versus Harris. The class of individuals, incidentally, what we're doing here is called slow media. It's called that by Cal Newport, who is the author of Deep Work. He's also the author of Digital Minimalism, which I finished last night. So we're doing slow media. That's a compliment. The class of individuals that plaintiffs identify within this group, those people that have a firearm in the AFS system, are those who already possess a firearm confirmed by the AFS database. Plaintiffs do not argue that this class of individuals should be exempt from further background checks. Rather, plaintiffs contend that these individuals should not be subject to a per se 10-day waiting period and should be able to take possession of their firearm upon passing the background check. Thus, under plaintiffs' arguments and challenges, this class of individuals will be required to undergo and pass a background check when they attempt to purchase a firearm. We're on Silvester versus Harris. The judge is Anthony Ishii, a Democrat judge, and he gets the right answer. Pay attention because I'm a Republican professor. I just gave a Democrat a compliment. Background check, page 29. Given the current BOF staffing levels, that's Bureau of Firearms, the potential additional research involved in reviewing a DROS application and the possible response times from other agencies and states, 10 days is a sufficient period of time in the clear majority of cases for BOF to complete a background check and approve or deny a DROS application. However, within the 10 days waiting period, background checks can be completed anywhere from 1 minute to 10 days. 20% of all DROS applications are auto-approved, usually within about 1 or 2 hours, and require no further review. The mandated 10-day waiting period is the only thing that stops BOF from approving the sale and releasing the firearm when a DROS application is auto-approved. 80% of all DROS applications are not auto-approved, and further review, analysis, and/or investigation is necessary to determine if a person is prohibited from possessing a firearm. For non-auto-approved DROS applications that are completed within 10 days, the 10-day mandatory waiting period is the only thing stopping BOF from approving the sale and release of a firearm. For all DROS applications that are approved by BOF prior to the expiration of the 10-day waiting period, conducting a background check is no longer a justification for the 10-day waiting period because the DROS applicant has been approved as determined by a completed background check. Although additional disqualifying information may come to BOF's attention during the 10-day waiting period, that can be said of any time frame, be it 1 day or 60 days. Moreover, that's a key thing that he just said, by the way. It is such a key thing because the reason they're giving would apply to an indefinite denial of a Second Amendment right. And maybe that's on purpose. And he's saying, I caught that. Moreover, the requirement in essence is to pass the background check. It is not to pass the background check every day for 10 straight days. Further, 20% of all DROS applications are auto-approved in a very short period of time, and they normally are not reviewed or rechecked at any time. Finally, of the approximately 99% of DROS applications that are approved, no new disqualifying information was obtained during the 10-day waiting period. Of the approximately 1% of DROS applications that are denied, there's no evidence regarding when the 10-day waiting period that the disqualifying information was obtained, i.e., was disqualifying information obtained during the initial BFEC, or it was obtained late in the process as a part of a recheck. Requiring an approved DROS applicant to wait the full 10 days when the application is otherwise approved and the applicant is already has a firearm, on the chance that new information might come in, is unduly speculative and anecdotal. If disqualifying information arises about an individual who has already taken possession of a newly purchased firearm, California has in place the APPS system, which is designed to retrieve such firearms from prohibited persons. The APPS system acts as a safety net for individuals who have been previously approved to possess a firearm, but who later become prohibited. Page 30. So what he just did was, this Democrat judge just said, Kamala Harris, defendant, your evidence, your argument is really bad as applied to the 10-day waiting period to people who already have a firearm in the system and pass a background check before 10 days. The waiting the full 10 days is arbitrary. You're violating their civil rights by reason of arbitrariness. This is the president, the presidential candidate of the Democratic Party. That's not a good sign. Cooling off period. The rationale behind the cooling off period is to prevent individuals from performing impulsive acts of violence to others or to themselves. The cooling off period seeks to limit a person's access to a firearm. Because 80% of DROS applications are not auto-approved, a waiting period of at least 1 day will naturally occur because the CIS analysts must obtain and review various information. If a person already possesses a firearm, then that person will generally have access to that firearm and may commit impulsive acts, violent acts with it. There's no evidence that a cooling off period, such as that provided by the 10-day waiting period, prevents impulsive acts of violence by individuals who already possess a firearm. So what Ishii's saying here is that can't be a good reason for the 10 days. A waiting period for a newly purchased firearm will not deter an individual from committing impulsive acts of violence with a separate firearm that is already in his or her possession. This is called critical thinking, people. Enjoy. There is no evidence that none of the submitted social science studies excerpts advocate for a 10-day waiting period or attempt to define 10-day waiting period as being supported by clinical or empirical evidence. The studies that are supportive of waiting periods are supportive in theory and seem to assume that the individual does not already possess a firearm. It is true that some individuals may not have ammunition for a firearm in their possession, or that the firearm may not be in working condition. However, no evidence attempts to quantify this, and it is unduly speculative to conclude that this is a common occurrence. If an individual already possesses a firearm and then passes a background check, this indicates a history of responsible gun ownership. Thank you. There has been no showing that applying the 10-day waiting period to all individuals who already possess a firearm will prevent impulsive acts of violence. In terms of the AFS database to confirm possession of a firearm, the BCEF can be modified to make simple check if a DROS applicant has a firearm within the AFS database. It is true that the AFS system does not contain every firearm in circulation in California, thank God. However, if a person has a weapon that appears within the AFS system database and that person's application is otherwise approved, defendant has not explained why it should be, defendant is Kamala Harris. Kamala Harris has not explained why it should be presumed that such an individual no longer possesses the firearm. Such a presumption is not supported by any identified evidence. Moreover, the AFS system is available to law enforcement personnel on a real-time basis in the field, and law enforcement considers the AFS system to be reliable. If a law enforcement officer in the field who is about to confront a suspect can use and rely on the AFS system and proceed with more caution, then it is unknown why Cal DOJ or BOF cannot also assume that an otherwise approved DROS applicant is still in possession of a firearm in the AFS system. Considering the absence of relevant data, law enforcement's real-time reliance on the AFS system and an otherwise approved background check, it can reasonably be assumed that a DROS applicant who has a firearm in the AFS system is still in possession of that firearm. The long or the short of this section is a cooling off period is not a good rationale for violating people's civil liberties, namely taking possession of a firearm when you buy it, when you pass the background check. Maybe there's a little bit of a wait. Straw purchases. Page 31. There is no evidence that the legislature implemented the waiting period laws in order to give law enforcement an opportunity to investigate straw purchases. In a straw purchase, Although it might be easier to intercept a weapon prior to delivery, this only occurs in about 15% of investigations. There is no evidence regarding the number of straw purchase investigations that lead to arrests or convictions or retrieval of firearms relative to the number of DROS applications. Further, although some straw purchasers have purchased other guns in the past, there's no evidence regarding how often this occurs. Straw purchase investigations, do you hear him saying over and over again, there's no evidence? This is speculation. There's no evidence. They're violating rights on no evidence. That's because they just believe in violating this right. That they're committed to violating this right. That's their commitment. And they're just assuming they're going to get a Democrat judge and he's going to see that there's not adequate evidence and he's just going to be okay with that because he's on board with that policy proposal as a Democrat. Well, they got the wrong Democrat here, Anthony Ishii, whose family was interred by Democrats, Japanese Americans, during World War II in California. Look it up. I'm having fun. I don't know about you. Straw purchase investigations begin when law enforcement officers review paperwork at gun shops, observe behavior and interaction at gun shows, or receive a tip from BATFE or a gun shop owner. Not all of the transactions observed or paperwork examined create a reasonable belief that a straw purchase is occurring. The agents only investigate a transaction if they have reason to believe that a straw purchase is occurring. Given Agent Graham's description of straw purchase investigations, the vast majority of transactions do not appear to be straw purchases. Applying the full 10-day waiting period to all transactions for purposes of investigating a straw purchase in the absence of any reason to suspect that a straw purchase is in fact occurring is too overbroad. If the law enforcement officers personally observe what they believe to be a straw purchase, be at a gun show or at a gun store, they may intercede during the purchase process. If the legislature believes that law enforcement should have additional time in which to investigate a straw purchase, then a statute could be enacted that permits law enforcement to cause a delay in the approval of a DROS application if law enforcement has reason to believe a straw purchase is occurring. Conclusion. As applied to individuals who already possess a firearm as confirmed by the AFS system, defendant has not established that applying the full 10-day waiting period when the background check is completed prior to 10 days is a reasonable fit. The 10-day waiting period laws as applied to individuals who already lawfully possess a firearm as confirmed in the AFS system and who pass the background check prior to 10 days violates the Second Amendment. Yeah! What about those who have a CCW license? Let's go to the background check. Plaintiffs do not contend that CCW license holders should not have to undergo and pass a background check. First, plaintiffs' proposed injunctive relief requests CCW license holders undergo the same background check as other individuals who are exempt from the 10-day waiting period. Police officers who are exempt from the 10-day waiting period pursuant to California Penal Code, blah, 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 must still pass the BFEC. Therefore, the BFEC standard background check would apply to CCW license holders when they attempt to purchase a firearm. Second, plaintiffs have expressly confirmed that all members of the as-applied challenges would still be required to pass background check when they attempt to purchase a firearm. The court's above analysis with respect to background checks for those who have a firearm in the AFS system also applies to CCW license holders. If the background check is completed in less than 10 days, then a background check is no longer a justification to make a CCW license holder wait the full 10 days. Also, the BFAE system can be modified to make a simple check through the AFS system to determine if that person has a valid CCW license. Also, you can just observe the license at the point of sale. Hello. Additionally, not only does the AFPPS system act as a safety net for any CCW license holder who may become prohibited from possessing a firearm, the RAP Back program acts as a further safety net with respect to California criminal conduct by a CCW license holder. How are you doing so far? Okay, just to clarify, a CCW license holder, by definition, is legally allowed to have the gun on them when they're purchasing the firearm. And it implies logically, not quite logically, but it does imply there's a strong inference you could make from the fact that the person has a CCW license, that the person has a firearm. And the reason is because in California, you have to have a firearm to have a CCW license. You have to have a firearm that belongs to you that goes on the license. And I don't think that that's the way it should be. Some states, you just have the license and you don't have to say which gun you're using or whether you even have a gun. I don't know why you'd want the license if you don't have a gun, but so why would you have to wait 10 days? You already have a gun on you, concealed. So why would you have to wait 10? What's the rationale for waiting 10 days for this other one? It can't be that you're dangerous. The state has just acknowledged you're not dangerous. And I mean dangerous in an immorally dangerous, I should say, because you want to be dangerous to criminals. And maybe there's a lot of criminals because you're not dangerous to them. Criminals should have danger directed at them. That's called law and order. Another word for that. Otherwise, you have chaos. Cooling off period. For CCW license holders who already possess a firearm as confirmed by the AFS system, the above analysis regarding a cooling off period for those who already have a firearm as confirmed by the AFS system also applies to CCW license holders. So he's going to say, Anthony Ishii, my favorite Democrat judge, he's going to say, you keep saying there's some rationale to make these CCW license holders wait the 10 days, and now we're on the cooling off period. They need to cool off. Well, again, they already have a gun on them. If they weren't cool off already, first of all, they'd lose their license. Secondly, they'd lose their freedom. For a CCW license holder who already possesses a firearm and is confirmed by the AFS system, the above analysis regarding cooling off period also applies to CCW license holders. For a CCW license holder who does not already possess a firearm, as confirmed by the AFS system, there is no evidence regarding unlawful firearm violence committed by CCW license holders. Thank you. Thank you, Judge. There is no evidence regarding a suicide attempts by CCW license holders or how long after a purchase of firearm that suicide by CCW license holders generally occur. The social science studies regarding waiting periods in general are inconclusive at best. None of the submitted social science studies presented to the court address suicide as it relates to individuals who must meet the type of requirements of a CCW license, and none of the excerpts advocate or defend a 10-day waiting, a 10-day cooling off period. The nature and unique requirements of CCW license are such that it is unlikely that a CCW license holder would engage in impulsive act of violence. The CCW license applicants must demonstrate good moral character. Now that's gone with Bruin, thank God. Just like you don't have to, say at the DMV, you don't have to demonstrate good moral character to get a license to drive. The same standard would apply. The shallow issue regime standard applies to firearm concealment licenses. Thank you to 6 justices on the Supreme Court. They're all Republicans. this is the Republican Professor podcast. It's my job to point that out to you and make you, connect the dots there. I wish it was more Democrats, and I would love to not have to do this podcast. Do you think I like doing this podcast? It's a pain in the ass. All right. If the Democrats weren't such, well, they really are hateful, and they don't learn from observation. I wouldn't have to do this otherwise. Just look up, just on this last comment, look up on YouTube. I'm going to share my screen. I'm going to do something. I'm going to depart from my normal thing here. And I'm going to show you, let's see, what did I just watch? My history here. I just watched this video. Let me share this screen here. So if you're listening on Apple Podcasts only, audio only, I'm not going to apologize for you because you are an adult and you can listen. I'll just describe what I'm watching. For those of you who are watching on YouTube, you don't need me to describe, but I'm going to describe for those listening on audio. I'm looking at my history on the YouTube channel, and I'm specifically talking about this one right here. WTF happened to Santa Monica, California. This is by Graham Stephan, 2.9 million views on YouTube. And he is going through, he's someone who grew up in Santa Monica, and he describes the change that has happened correlated with absolute Democrat control of California. And so I would take a look at this. I'll link this in the description, because it's really quite sad.
Here's the big secret.
It's really quite sad what's happened, correlated with increasing Democrat control in California to some of these places. And I know some places are not, as harmed as others, but the whole state has been harmed. And that's a very good episode there. So I would just suggest that when you watch that, just listen to the interviews. First of all, people don't want to be interviewed because they're scared of Democrats. They're scared of being attacked by Democrats who caused all that stuff in the video. He himself suspects that the nadir of Democrat control, I don't know if it is the nadir, but it certainly was the breaking point of a point of no return, it seems like, was the Democrat riots of 2020. And that's he says that in minute 12 of an 19 minute video. And I've been on the campuses for 2 decades, 12 colleges and universities, 190 courses, 3 counties, which total include a population of more than several states, maybe even more than half of them. Starting in a geographical area that's in many cases were dominated by Republicans for decades, like, for example, Ventura County, where I taught, parts of LA County. I mean, the 118 goes right through North LA County, through the valley. It's called the Ronald Reagan Freeway. That's what it's called. There were Republicans there at once upon a time. And in Orange County, okay, And we still have a Republican congressman who is a woman, but the word man is gender neutral, as you'll know when you look up 1828 Noah Webster's dictionary. And at the time I started teaching, there was a Republican governor of California. There were Republicans in the legislature. Housing prices were affordable. There were jobs. There was not great inflation on campuses, at least not near what you have now. There was more of an attention span for the electorate. There was more hope. People could get a job. The crime was responded. The response to crime was reasonable, a lot more reasonable than it is now. And gradually, Democrats increased their control in California, and all of those descriptions, those positive descriptions I've just mentioned, morphed into the opposite. And my point is that when you watch that video on YouTube, that what WTF happened to Santa Monica, when you watch that, I'm going to share my screen again. I got this stupid ad. I'm sorry.
About women.
Sorry, it goes to this ad, and I don't want to have the ad, but I don't know how else to do it. Let me, I don't want to have a copyright issue here. Just observe the, let's see here. Just observe the title here. WTF happened to Santa Monica, California, by Graham Stephan. Just observe the interviews that he does. And, you know, Democrats who live there will admit all the bad things, but they don't make the connection to politics. They don't make any because they hate Republicans so badly. They never blame Democrats for what Democrats control. All you have to do is ask if these outcomes, these poor outcomes, like in Santa Monica and other places in California, really the whole state, if those outcomes were correlated with Republican control of the state, would you blame Republicans? Of course you would. Of course they would. They don't blame Democrats when Democrats are in control. That's the Democrat electorate. It's like they can't effectively take in evidence and critically assess with critical thinking skills their own biases. They don't have self-awareness. That's actually the most scary thing about where we're at. I don't blame Democrat politicians. They wouldn't be there if it wasn't for a Democrat electorate. And you have to think about what's happening with the electorate. I'm trying to counteract that, but I'm just one person. If a person does not pass the background check, they cannot obtain a CCW license. CCW license applicants must demonstrate good cause either to a sheriff or local police chief in order to obtain the CCW license. Again, that's gone now that Bruin got rid of that. And a sheriff or chief of police may impose reasonable restrictions on as a part of the CCW license. Thus, CCW licenses are not issued without reason and individual consideration. If there is sufficient cause to believe that an applicant has or is experiencing mental health problems, then a sheriff or police chief may require that the applicant undergo psychological testing. If a person is mentally unstable with respect to themselves or others, the psychological testing could detect that problem. With the exception of passing a EC standard background check, none of these CCW license requirements must be met by an ordinary California firearms purchaser. Finally, once issued, a CCW license allows its holder to carry a concealed handgun in public for 2 years, generally throughout the entire state of California. If an individual has met requirements for obtaining a CCW license, and thereby, again, under the old rules, and thereby has demonstrated that he or she can be expected and trusted to carry, I hate that term trusted, I hate it, trusted. For the First Amendment right to go buy a book and read it and have your own thoughts about it and talk about it, is it because we trust you to have that book? It's so creepy. Trust? What are you talking about? Trust? I don't need your trust. I'm sorry. Trusted to that he is a Democrat judge, so trusted to carry a concealed weapon in public for 2 years. It is unknown why that person would have to wait 10 days before being permitted to take possession of a newly purchased firearm. Imposing the 10-day waiting period as a cooling off period on a CCW license holder is speculative, and its effects appear remote at best. And I would even say, if he was a Republican judge, I would say it's not the effects appear remote. The effects are immediate. They are an immediate denial of his Second Amendment rights. That's immediate. Straw purchase. The court's above analysis with respect to straw purchases for those who have a firearm in the AFS system also applies to CCW license holders. There is no data or evidence. I should say there are no data. If he was a Republican judge, he would say there are no data. There is no data. Now, I'm just quoting. I'm quoting. Data is plural. Democrats, data is plural. There are no data. There are no data or evidence regarding CCW license holders engaging in straw purchases. The requirements for obtaining a CCW license strongly indicate that a CCW license holder is unlikely to engage in a straw purchase. Yeah, I mean, there you go. Conclusion: as applied to individuals who hold a valid CCW license, defendant is not established. Defendant is Kamala Harris. Kamala Harris has not established that in applying the full 10-day waiting period when the background check is completed prior to 10 days is a reasonable fit. Therefore, she doesn't care about reasonable fit at all. She only cares about violating rights and using any excuse, any fake manufactured evidence to do that. That's what he's saying. I'm not saying it, he's saying it. He's being nicer, but wait till the end. Maybe he's not nice. Those who have a COE. COE is a certificate of eligibility. I mean, it's the same thing. Here's the order. The court has found that the 10-day waiting periods of the California Penal Code, blah, 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 violate the Second Amendment as applied to certain groups. People. Let's explain why Democrats have a problem with this. You have ordinary statutory interpretation. You have an old statute, conflicts with a later statute, the later statute wins. That's what the Democrats think is going on here with the constitutional law. They have a problem with constitutional law, the very idea of constitutional law. Okay? And the very idea of constitutional law is that you have Constitution. You have a later statute that conflicts with the Constitution. The Democrats think that the statute wins because this is just, ordinary statutory construction. See, we're progressive. They think they're progressive. I think they're progressively making things worse, but they think that they're just progressive, and that's how they look at it. So the later is by definition better. It's what C.S. Lewis called chronological snobbery. But constitutional law, this is how it works. You have a constitution. You have a later statute that conflicts with the Constitution. Constitution wins. not just legally, but morally. Why morally? In our case, the Constitution expresses a natural law that is rooted in a pre-existing morality that's legitimate. That's the way things are as far as morality goes. It is a natural law that you ought to be able to defend yourself, and that right has not been bargained away at the founding. It was protected in the positive law at the founding. Not only that, but in the separation of powers protects individual liberty. That's the moral arc of the Constitution, is to prevent tyranny and to prevent being a victim of tyranny. And tyranny could be from the government. It could also be from criminals. Wherever the threat is, to be able to resist that. And there's a deep teaching here about separation of powers that the Second Amendment flows out of and is naturally added to. It's an outgrowth of the view that separation of powers protects individual liberty. What better separation of power is there than between the citizen and the government, between the citizen and that which would be tyrannical? And that would include criminals, ordinary criminals, in a criminal confrontation. Even at the founding, I mean, people are people. They're still criminals. And a criminal, by definition, is someone who seeks to, in this context, do immoral violence. And self-defense could be violent, but it's not immoral violence. By the way, I'm not just bloviating here. I mean, I want you to do a Google search. Individual liberty, constitutional statesmanship. I'm the #1 Google result in the world on that. The Republican professor. It is very difficult. It's almost impossible to get a #1 page result on Google search. People spend a lot of money trying to get that. I didn't spend it was all hard work for me. It's almost impossible to get Google, a #1 page Google search result on anything related to Donald Trump. I have a #1, not only page, but #1 result on the first page on a topic related directly to Donald Trump. And that is the figure of Brett Kavanaugh, who is on the Supreme Court. And again, it is virtually impossible for someone like Brett Kavanaugh, where there's been so much vitriol, so much hate, so much written, so much video, everything, to even appear on the first page of Google results. And I'm in the #1 position. Individual liberty, Brett Kavanaugh. I'm the #1 result. I'm also on the first page, although I'm not the #1 result, but I'm on the first page. I think I'm a #6 on page 1 of Google search results for separation of powers, Brett Kavanaugh. I've done a lot of thinking about separation of powers and individual liberty. I'm the #1 result on individual liberty, constitutional statesmanship, individual liberty. #1 Google result in the world right now. And it's been that way for months. I checked last year. I was #1 last year, and I'm still #1. I checked a few days ago. Might have been changed in the last couple of days, I guess, but I'm not just bloviating here, people. I wrote a 450-page book about this. I've thought deeply about this. I've done a lot of hard work. I don't care about SEO. I don't care about search engine optimization. I break all the rules. Every time I post something, it tells me, the Democrat tech tells me, red, don't do that. And well, I'm #1 Google result. So obviously I'm doing something different than they're telling me to do it. And I'm #1 Google result on highly controversial things. Not only Donald Trump, but Brett Kavanaugh and Donald Trump. Brett Kavanaugh is controversial because of Donald Trump. He wasn't controversial before Donald Trump. Funny how that works. Well, actually, he was a little bit, but yeah. Interesting. All right. Well, I enjoyed spending time with you. We'll see you next time.